Everyone, we'll just give it a few more seconds here, and then we'll start. Great. Well, good afternoon and welcome, everyone. My name is Jason Abel, and we're thrilled to have you as part of our 7th annual State of Voting Rights panel, sponsored by the ABA section of Civil Rights and Social Justice. It's one of our many in a series of rapid response webinars that we're actively planning additional programming. So please feel free to visit us at americanbar.org/CRSJ for updates on these programs. So before we begin, I'd like to turn it over to the section's chair, Juan Thomas, with some introductory remarks. Juan.
Thank you, Jason, and welcome everyone. I'm so honored and pleased to be with you this afternoon as we talk about the importance of voting rights and the continued discussion around protecting our democracy and the rule of law. You know, last week, we heard a U.S. Senator say that voting, in a real sense, is a sacred prayer that we often use to express what we want to see in our democracy. I lift that statement up because during this time of year, many of us are celebrating our faith traditions, and voting for many of us is a sacred prayer with respect to how we want to see our world. And for those who do not have a particular faith tradition, you still understand, many of us understand the importance of voting and how the importance of voting impacts our democracy and the rule of law. And so today we gather to continue that discussion. And I just want to thank everyone in our section who has been devoted to this work for many years. This particular year, our section launched a Protecting Democracy project. And I want to thank publicly Elizabeth Yang and Dr. Cynthia Swan, who led that effort on behalf of our Civil Rights and Social Justice section. And so I just want to thank you, Jason, and the entire panel for all the work you are doing. Look forward to a enlightening and educational conversation, and let's continue to do the good work. Thank you.
Great. And thank you, Juan, for your leadership and guidance. We're very excited to be back with you all today. We have an amazing panel that will touch on every aspect of our elections and voting. I'd also like to take just a couple of minutes to thank a few folks who have helped not just with the program today, but with the amazing work of the section of Civil Rights and Social Justice on a day-to-day basis. First of all, obviously our section chair, Juan, my fellow co-chairs of the Civil Rights and Equal Opportunity Committee, and most importantly, thank you to the amazing staff of the section, Paula Shapiro, Ali Kielsgaard, and Ruchika Sharma. They work tirelessly to provide vital programming for our legal community. So today we find our democracy at a crossroads. With the aftermath of the 2020 election still front and center, we just finally, or almost finally, as Keela will talk about, finished the 2022 midterm elections. Meanwhile, the Supreme Court is currently considering 2 significant cases that may define our very democracy itself. So we are lucky to have a stellar panel today to address all issues surrounding our democratic system. We will attempt to cover a lot of ground, from election protection to working as an election official, from arguing in the highest court in the land to advocating in the halls of Congress. Our panel has it covered. So during today's program, we encourage you to ask questions of our panelists through the Q&A, not the chat function. If you do not see the controls, please ensure your screen is not idle. We will address questions at the end of the program, time permitting. We will be sharing a recording of the program to everyone who has registered so that you can share it widely with your networks. I'll briefly introduce our panel, then turn it over to each of them to discuss the various issues that have kept them busy over the last election cycle and what they're currently working on. So first, we're going to start with Keela Crane. Keela is the Deputy Legal Director of the Michigan Department of State, where she guides the office on a variety of issues, including elections. Keela has been tasked with the implementation of the state's new independent redistricting commission and voting laws for the state. Prior to her Michigan service, she was the Assistant General Counsel of the NAACP and was also chair of the National Bar Association's Young Lawyers Division. Next is Adam Ambrogi. Adam is the Senior Director for Voting and Elections at the National League of Women Voters. He brings his history of voting rights experience to that role, having previously served as the Director of Elections and Voting Program at the Democracy Fund and as Chief Counsel of the Senate Rules Committee, where I had the privilege of working with him now, seems like a long time ago. Next, we have Abba Khanna, who is a partner in the Elias Law Group and works in the firm's litigation practice. She focuses primarily on voting rights and redistricting, and most recently briefed Moore v. Harper and argued Merrill v. Milligan in front of the Supreme Court. She frequently guest lectures at law schools on election law, trial practice, and redistricting. And but if that's an open offer, I might want to take you up on something this upcoming spring. Finally, we have Caleb Jackson, who's policy counsel for the Lawyers Committee for Civil Rights under Law. He has litigation experience as a voting rights attorney and is engaged in a variety of policy matters currently. Additionally, he's worked on labor matters, representing national unions and also a class of workers in an employee misclassification and race discrimination case in federal court. Special thanks to Caleb for stepping up at the last minute. We're very appreciative and thrilled to have him with us today. With that, I'll be quiet and let our panelists take it away. Keela, why don't you kick us off?
Thanks so much, Jason. Before I begin, I want to say thank you to Jason and everybody at the Civil Rights and Social Justice section of the American Bar Association for having us here to present to you all about the state of our voting rights. Also want to give greetings to, in this capacity, Chair Thomas, in another capacity, past President Thomas, for inviting us to be here. It's great to work with you and your continued commitment to civil rights and social justice. So I bring you greetings from Ann Arbor, Michigan, the home of the Wolverines, and the Department of State and Secretary of State Jocelyn Benson. Want to talk a little bit to you about the state of voting rights here in the Wolverine state. You might hear me say Wolverines a lot because we're super excited about our football team and where they're headed in a couple of weeks. So the state of voting rights here in Michigan is improving. We are excited about the trajectory of voting rights here and what the citizens of the state of Michigan have done and will continue to do to improve voting rights and access for all Michiganders. Since 2018, voters have implemented 2 packages of constitutional amendments that have expanded voting rights. Proposition 2018-2 and Proposition 2022-2, which expanded access to the vote. In 2018, there were several different amendments that allowed Michiganders expanded access, such as the right to vote a secret ballot, the right to have no excuse absentee voting. So that means any Michigander that wished to do so could vote via an absentee ballot once you applied for that absentee ballot, allowing for straight party voting so that they can just bubble in one party or another, and that will complete all of their partisan election voting for that particular party. The ability to automatically register to vote anytime that you interact with the Secretary of State's office. That has proved to be pivotal for many Michiganders who interact with our office, as we are a hybrid both of the DMV as well as the Chief Elections Officer for the state of Michigan. The ability to register to vote up to 15 days prior to the election via mail or online, and the ability to do same-day voter registration. So up to and by 8 p.m. on election day, any Michigander can go to their local elected official or their local clerk's office to register to vote. You may have seen reports about the wonderful students at the University of Michigan and Michigan State who were in line very late in the evening or early morning on November 9th that were continuing to register to vote because they were in line at 8 p.m. They were allowed so to do. I was there with those young people who were excited, eager to cast their ballot, to make their voices heard in our election. And that was all because of what the voters did in 2018 to allow for same-day voter registration. In 2022, the voters continue to move our democracy forward in the state of Michigan. For expansion of their fundamental right to vote, we enshrine into law the aspect that a person could attest to their identification via an affidavit of identity. So if they did not have or did not bring a government issued identification card or something from their school, they can fill out an affidavit of identity. That was law in Michigan, but it was now enshrined into the law via the constitutional amendment. I put an asterisk by this because we're currently under a recount in the state, and that will hopefully conclude this week. So that's why Jason says that here in Michigan, our 2022 election cycle has not ended just yet. Some other enshrinements that the voters overwhelmingly voted for in 2022 was a state-funded prepaid postage to return all absentee ballot applications. So you're not have to worry around going to get a stamp. You can go ahead and just submit that in, and you'll be able to submit your application. And also, when you apply for an absentee ballot application, you only have to do that once, and you will be able to get an absentee ballot continually for your ability to cast your ballot in that method. Also, we have enshrined 9 days of early voting here in the Wolverine state. So we are continuing to expand access to vote, which all of our rights really rest on our ability to cast our ballot. Also want to expand participation. In 2018, 55.4 eligible Michiganders went to the polls and cast their ballots. So that was 4.34 million Michiganders went to vote. In 2022, we increased that to 4.5 million of our fellow Michiganders exercised their right to vote. And because of the expansion from 2018 that allow folks to vote via absentee ballot, we are seeing a surge in the participation. Of course, when 2020 happened, and that was in the height of our COVID, in the COVID pandemic, when we were very concerned about interacting with people in large spaces, we saw a much higher turnout for absentee ballots. It dipped a little bit in 2022, but we saw that, of course, across the country where a lot more people were taking advantage of that opportunity in the height of COVID. There still is a pandemic, but we're more comfortable around each other. So we saw a bit more in-person activity here in our state. But that doesn't, while there are great things happening here in the state of Michigan, we all know that our voting rights, there's things to work on as we're talking about voting rights, not just here in Michigan, but across the state, or across the country rather. We know that 27 secretaries of state were on the ballot in 2022, but too often we saw folks who were going to be or wished to be the chief elections officer in their state were actually election deniers from 2022. So you have the tale of that folks were denying that an election was properly, securely done in their state, but then asked the voters to be the chief election officer for said state. We also saw that secretaries of state are still under attack, including my own here in the state of Michigan, Jocelyn Benson. There is a link to, in the information that you'll receive after this webinar, you'll see a link to a interview that our secretary gave about the threats of attack for herself, as well as some of our workers here in the Bureau of Elections in Michigan. And where states where there was such concern and discussion about the election in 2022, all of their secretaries of state were on the ballot. And it so happens that every single one of them won re-election and that were eligible to be re-elected in that election. So Arizona, Georgia, our secretary here in Michigan, Nevada, as well as Wisconsin. And as we look forward to the future of voting rights for those who are completed their process in their election, there are things that we are thinking about here in the state of Michigan that I ask that you all also think about when you're considering how do we advance voting rights? How do we make sure that everybody has an equal, unfettered access to the right to cast their ballot? We need to expand the conversation about what it means to be able to exercise your right to vote. Do you have the right to receive and decide on accurate information? AKA, we need to end the proliferation of lies, full stop. It is egregious to us that you can peddle in lies as it pertains to things around elections. We need to be able to elect people based on true, accurate information. There are policy differences, of course, and then there are lies about people, about policy, and about outcomes that are disastrous to our democracy. We need to have the right to access the vote on more than just a Tuesday and set hours. People around the globe vote on days that are not days of the week and that are not specifically Tuesdays. And we need to do that more across our country. We're so excited about what the voters have elected to do here to have early voting. And many other states are moving forward with no excuse absentee ballots, early voting options, and more flexible voting. But we need to continue to move that forward because we know that there are people who work tremendously hard, multiple shifts every day or many days of the week that can't take out the time to go vote on a Tuesday. And we need to give everybody an option, no matter what they do and where their station is in life. If they are eligible to vote, they should be able to cast their ballot. And lastly, but most importantly, we need to have the right for election workers to operate free from intimidation, risk of threats, and bodily harm. For someone who is working with folks who help to operate elections in our state, it is heartbreaking when you hear the exhaustion of folks who are charged to lead our democracy here in Michigan, that they're just tired, not to mention the potential death threats that they receive via phone from folks who have been told those lies and just out and out mistruths, and then are calling angry based upon those mistruths and talk about that to our staff. I have talked to many of the workers in the Bureau of Elections who are doing tremendous work. You would be surprised that many of them have not had a big break since the 2020 election because so much goes on in between elections, getting ready for one, concluding out another. And we here in Michigan have election every year. So I just want to pause and say thank you to all of our election administration workers at the Bureau of Elections and all across our state and country who know the importance of defending and upholding our democracy, even through this crazy time of threats to their lives and the lives of their families. So again, looking towards the future, we want to increase about how information about elections are administered. It's really important that folks understand how and who administers their elections. And that should be happening not just in the run up to elections, but all year round. So AKA next year, I'm looking forward to tag teaming with Jason to talk more about how elections are administered. Also, while elections are ultimately about wins and losses, emphasizing why elections matter and what the election officials' roles and responsibilities are critically important. Often we hear about, well, why can't you do this or that? And that might not actually be that person's role. For example, here in our state, our local elected officials really run the show. While the secretary has oversight ability over our elections officials, it is really here in our state local elected officials who are the ones that are driving our democracy on our city level, township level, and up to the counties. So it's important to know who does what and when. And then also preparing for the 2030 census and redistricting process, something that is near and dear to my heart. We want to engage the elected officials and government workers now who are actively preparing for these events, making sure that there's enough funding for the 2030 census, making sure that you can ban prison gerrymandering and other types of gerrymandering that make it difficult for people to be able to cast their ballot and elect candidates of their own choice. So there's so many things that we could be doing to get ready for that process. Also, making the goal that every citizen can and does vote. So we want to celebrate the increases that I talked to you about earlier here in our state, but we need to have a goal of getting closer to 100%. While we applaud the 55%, it's not enough that just barely half of our Michiganders who are eligible exercise their right to vote. We need to be marching closer to that 100%. And we need to eliminate barriers that inhibit folks from doing so. And lastly, with new trends also come new challenges. Increased monitoring of drop boxes has caused anxiety among many Michiganders and folks across the country. And increased challenges or preparation for challenges to in-person and absentee voting, we need to be on the lookout for that. Teaching for an outcome versus teaching for a law. We have seen a lot of folks that are trying to prepare election challengers or folks about elections generally, but they're teaching for an outcome, how to potentially be disruptive or how to advocate for a specific position, besides actually teaching what the law says currently about your elections in your state, in your county, in your city. And also making sure that the expansion of rights does not become a barrier in reality. Again, as we saw in our two largest campuses here in our state, Michigan State and University of Michigan, while I'm so excited that the young people waited for 6 hours to be able to vote, we definitely need to figure out how we can work with them so that they're not waiting to the last minute to cast their ballot, and thus turning a great thing, which is same-day voter registration, into a burden because they don't have the time to wait for 6 hours to cast their ballot. And so, again, voting rights here in Michigan, we're excited, but there's so much more work that we can do, and we're excited that our secretary was reelected so that we can continue that great work with all of our Michiganders. So thank you so much for having us here today, and I'm looking forward to your questions later on in the webinar.
Hila, thanks very much. And, this is our 7th year of having this panel, and I believe you are the first election official to join us. So there's a long overdue voice to add to this discussion. We really do appreciate it. I am noticing folks are posting in the Q&A. That's great. What we'll do is we'll try to consolidate some of these questions and ask specific questions afterwards. So trust me, we're seeing it. I just got word that Adam is having a little bit of technical difficulties. We're going to get him back. So in the meantime, Abba, can I turn it over to you?
Sure thing. Thanks, Jason. And thank you, Kyla. That was amazing. It's really great. I agree. It's really great to be able to hear from election officials and your perspective. I know Michigan's always had a lot from the litigator's perspective, a lot of post-election and pre-election litigation. So I really appreciate everything you're doing to protect the right to vote. As Jason mentioned, I'm a partner at Elias Law Group, and I focus on voting rights and redistricting litigation. In particular, I head the firm's redistricting practice, and over the course since the 2020 census, I've overseen some 20 redistricting cases, some of which are still ongoing. To the extent anyone thought that redistricting ends after the first election cycle or with November 2022, you would be sorely mistaken. As someone who litigated redistricting cases well into 2019, I think actually technically one of my redistricting cases from last cycle is still open for this cycle. So these things do go on, and for good reason, right? Redistricting has massive implications for voters across the state and for numerous elections every 2 years, particularly when it comes to congressional redistricting. So it's important that we all recognize that these issues remain live and they remain critical to making sure that we have a fair representative system. I'm going to talk today about 2 cases that I've been litigating over this past election cycle, this past redistricting cycle, both of which have ended up in the Supreme Court. And they're different in some ways, but obviously both of them about redistricting and both of them really about where are we when it comes to the ability of our courts to protect plain people's right to vote for a variety of reasons. So the first one is Merrill versus Milligan out of Alabama. That's a race-based racial discrimination claim under the Voting Rights Act. And the second one is Moore v. Harper, which I'm sure a lot of you are familiar with. It just been in the news this last week where they held argument. And that's a state constitutional partisan gerrymandering claim. So the sources of law are very different. Kind of the claims are obviously very different, but I'll touch upon both just to give you guys an overview of what I've been working on and what the key issues are in each case. So in Alabama in 2020, the census revealed that there had been some population growth in Alabama as elsewhere, but not enough to change the number of congressional representatives to which it was assigned. So Alabama has had 7 congressional seats since the 1990s, I believe. And interestingly, what the 2020 census showed us is that the driver of that growth has been exclusively minority population and minority voters. So I think the Black population increased by some 6.5% over the last decade. The white population actually fell by nearly 2% over the last decade. So the population growth over the last 2 or 3 decades has been driven by minorities. Yet the number of districts in which Black voters have the opportunity to elect their preferred candidates, their preferred congressional candidates, has remained stagnant since the 1990 cycle. In the 1990s, there was a lawsuit under the Voting Rights Act, and the federal court issued a new redistricting map that basically, for the first time, provided a district in which Black voters were a majority of the voting age population and in which they could elect their preferred candidates. So as of the 2020 census, Black voters comprise some 27% of the population in Alabama, but still have just 1 out of 7 congressional districts, so 14%, in which they can actually elect have any opportunity of electing their candidate of choice. We filed a lawsuit challenging the congressional map in Alabama on the very day it was signed by Governor Ivey in November, and basically said that under Section 2 of the Voting Rights Act, Alabama should have a second congressional district in which Black voters are afforded an opportunity to elect their preferred candidates. Section 2 of the Voting Rights Act is in many ways a very straightforward, it is a very high bar to meet evidentiary wise, but in terms of what the test is, it's actually quite straightforward, and I'll map it out just to lay the kind of the legal framework for you all here. Section 2 basically says that you can prove voting-related discrimination, particularly in redistricting, without proving discriminatory intent. Basically, it's called a results-based claim, which says that as a result of the challenge practice, here the congressional map, that law interacts with social and historical and political conditions on the ground so as to deprive minority voters, in this case Black voters, of an equal opportunity to elect their preferred candidates. Back in 1980, the Supreme Court actually issued a decision in a case called City of Mobile versus Bolden, where it said, actually, under Section 2, you have to prove intentional discrimination. You have to prove not just that minority voters are somehow having their voting rights abridged or that they're on unequal footing, but you got to prove that racial discrimination was the intent behind the law. Congress came back in 1982 and unequivocally rejected that idea and said, no, race discrimination is not the plaintiff's burden in a Section 2 claim. And that's for a few very good reasons. One is that it provides an inordinate bar, proving intentional discrimination, digging into the hearts and minds of the legislators to prove that race was the thing that they were targeting is really making it a largely insurmountable and very expensive burden for plaintiffs to actually litigate. And more importantly, the idea of whether or not there was, racial animus actually driving the electoral process actually asks the wrong question. Because the question is whether, as a result of that law, when it interacts with a decades and centuries long history of racial discrimination, of political polarization, and all the social and economic fallout from that, does it result in discrimination against minority voters? Because the Voting Rights Act seeks to stamp out that result without having to smoke out some racial animus that's at the heart of it. So in 1986, the Supreme Court established a test for proving a Section 2 claim specifically for redistricting. That requires plaintiffs alleging a Section 2 claim to establish 3 what they call the Jingles preconditions. This is in a case called Thornburg versus Jingles. And that requires plaintiffs to establish first that there could be a potential district drawn in the map in which minority voters, Black voters here, could comprise a majority of the voting age population. It's a reasonably compact district. So basically the idea is that they are sufficiently numerous and reasonably compact. They're located close enough to comprise an additional majority Black district in a hypothetical map. Second, we have to establish that the Black vote is politically cohesive. Black voters are voting for the same candidates over and over in elections. And then third, we have to establish that white bloc voting operates to cancel out the Black vote and defeat the Black vote. Usually, I think is the word that they use, but in Alabama, that really is not even a question. So those first 3 preconditions, once plaintiffs establish those, then the court can move on to what they call the Senate factors. And that's really this discussion of the social and the political and the historical conditions of political life on the ground in the jurisdiction. And there courts have a lot of flexibility to look at a number of factors, but specifically look at the history of discrimination in voting. They look at racial appeals in electoral campaigns. They look at the extent to which discrimination has yielded disparities in other areas, in education and employment and in income that have that hinder the access to the political process, and a number of other considerations. So that's the kind of the lay of the land. We bought this lawsuit as soon as the map was filed, and we said that there should be another opportunity district in Alabama. Our lawsuit was consolidated with 2 others for purposes of a preliminary injunction hearing that was held in January. The first of, I think it was the second or third of the year, was held over Zoom. We held a 7-day hearing trial over Zoom, or preliminary injunction hearing, during which the court heard I think some 16 witnesses. And basically we brought forward, the key part of this case is that we brought forward experts who had drawn alternative congressional maps showing that it was possible to draw an additional majority Black district. Remember, that's that first Jingles precondition. The other issues, are Blacks politically cohesive? Absolutely. 95% of Blacks are voting for the same candidates in elections. Is there white bloc voting? Absolutely. Fewer than 15% of whites are voting for those Black preferred candidates. And does white bloc voting usually defeat the Black preferred candidate? Not just usually, but every single time. Unless the district is a majority Black district with a substantial number of Black voters, the white majority always uniformly defeats the minority preferred candidate. We met our burden on that front, and then proceeded to present a lot of evidence on those kind of Senate factors issues, the social, political, and historical conditions, many of which were largely not really in dispute, and many of which I'm guessing wouldn't surprise anyone to know that, while there have been some gains over the past many decades, including since 1965, there still is a lot of work to be done in Alabama and elsewhere. The district court issued a 225 plus page opinion, establishing that finding that we had basically satisfied the test for Section 2 Voting Rights Act claim. Went through each and every finding on each and every factor that I just outlined. This was in January of 2022 of this year. The state defendants moved to stay that ruling so that we could not proceed to remedy pending their appeal to the US Supreme Court. The district court denied that stay, but then they went to the Supreme Court, and the Supreme Court stayed that ruling in our favor. So the district court had ruled we won on our Section 2 claim. We are entitled to a remedy of an additional congressional district in Alabama in which Black voters have the opportunity to elect their candidate of choice. The Supreme Court said, pause, and held that victory until it decided the case on appeal. There was no court opinion that accompanied that official opinion, but there were several concurrences and dissents. Justice Kavanaugh's concurrence, which was on behalf of him and Justice Alito, basically pointed out that their basis for the stay was timing. The idea that it is too late. It was too late in January of 2022 to change the district lines that had been established in November of 2021 and that had been litigated in a record time thereafter. Basically, it was too late for the state to really do anything about that on remedy, and that was basically the driving factor. Chief Justice Roberts dissented and said, while he thinks there might be some reconformulation of the Voting Rights Act, or maybe that revisiting of the Voting Rights Act standard, the plaintiffs here followed that test to the letter and established a Section 2 violation, and that map should go forward for 2022. And I think Justice Kagan and several other justices dissented and said that the map should be in place for 2022, given that we'd already met our burden. The end result of that is that for 2022, the enacted map that we had challenged was left in place. And we would argue it's a map that was in violation of federal law, that voters voted under that. And then the case went up on the merits to the US Supreme Court. And we argued that I argued that in front of the Supreme Court in October of this year. And the interesting part about the case, about what is the issue on appeal, it really is all about that first Jingles precondition. It's not about whether or not there's racially polarized voting in Alabama. It's not about the social, political, and historical conditions in Alabama. The question that the state of Alabama posed to the US Supreme Court was whether or not the demonstrative maps that plaintiffs were required to bring forward. Remember, we have to show a map in which there are a new district with a majority voting age with a Black majority voting age population. Whether our maps were unlawful, whether our maps could establish a Section 2 violation. And basically their claim was, because our experts took into account race alongside other traditional redistricting factors, like compact district, like county boundaries, like communities of interest, that rendered our maps unlawful. It made them themselves racial gerrymanders somehow, and that it basically meant that we could not satisfy a Section 2 claim. This was a novel argument, and certainly one of first impression. The argument then kind of proceeded to the Supreme Court. If anybody heard the argument or read the briefs, there's a bit of a sliding scale of kind of what the argument was. On the one hand, I think Alabama seemed to be arguing that we should re-inject a racial discrimination intent claim into Section 2, the one that the Congress disavowed in 1982, the one that courts have established is not the standard, that really we should come back to a time where the only thing that plaintiffs must establish, regardless of racially discriminatory results, they must establish racially discriminatory intent, racial animus. At other times, it seems that they are basically saying that even if we were to keep this general results test, plaintiffs need to come into court with what they would call a race blind map. And I think a lot of the arguments, both in the briefs and in the Supreme Court oral argument, was about the extent to which race blindness is actually the goal of the Voting Rights Act and the mechanism by which you prove it. And that, I think, was the central area of dispute. Ultimately, we say, legislatures do not draw maps race blind. They are well aware of the racial and other demographic factors when they're basically, as they should be, when they're consolidating people into representative districts. It's important to know the demographics of those people to make sure that they have their interests reflected and the shared interests are being grouped together. But I think, ultimately, I think it does point to kind of a philosophical fork in the road for the Supreme Court and for litigants now to say, do we understand race-based voting-related discrimination to be a function of race? And when we're proving that, when we're arguing that in court, do we basically have to assume that race is not an issue? Are we supposed to come into Alabama and cast off 200 plus years of racial discrimination when trying to prove that the map interacts with the social and political and historical conditions in a way that results in a discriminatory map? So I think that was that will TBD on what the outcome of that is going to be. I am hopeful, and our position was, if it ain't broke, don't fix it. This test has been working for 40 plus years. It is, for all the on stare decisis, the Congress has approved it. It really has been just the mainstay of the Voting Rights Act, even while other provisions of the Voting Rights Act have fallen under attack. And we urge the court to basically continue that case, that precedent, and under that precedent that we've fully established our case. So we're hopeful to get an opinion on that before the end of this term. I know I've been talking a lot. I'll go really briefly to Moore v. Harper. I know a lot of people have heard about this, and so maybe you're more up to speed on that. In that case, North Carolina legislature passed what we called a partisan gerrymander. We filed a lawsuit under the state constitution, the North Carolina state constitution, specifically its free and equal elections clause, its equal protection clause, and its First Amendment, all of which are provide more robust protection for voters than the federal constitutional analog. As you'll recall, in 2000, at the end of last cycle, in a Supreme Court case called Prieto v. Common Cause, the U.S. Supreme Court said that the federal courthouse doors are closed to partisan gerrymandering claims for lack of a judicially manageable standard. But it specifically said that state courthouse doors remain open and that state constitutions provide remedies, provide opportunities so that these partisan gerrymandering claims do not echo into the void. There was very little factual dispute. We had an expedited trial before a 3-judge court in North Carolina. It went on appeal before the North Carolina Supreme Court. It was a long and drawn out process over a very short amount of time, all overlapping at the same time with the Alabama trial as well. But ultimately, I think there's very little dispute that what the North Carolina legislature enacted was an extreme partisan gerrymander. The question that the legislature brought to the U.S. Supreme Court was whether or not the North Carolina Supreme Court gets to enforce state constitutional provisions to strike down congressional maps. And their theory is that under the Elections Clause of the U.S. Constitution, which empowers state legislatures to determine the time, place, and manner of federal elections, state courts and state constitutions have no role to play. And legislatures basically have unchecked authority to act in contravention of state law, including state constitutions. If that sounds like a major upheaval, it's because it is. And our team represented the Harper plaintiffs. We were consolidated with one other case, and then an intervener as well, Common Cause, and the North Carolina League of Conservation Voters. And that case went up before the Supreme Court in a very heated oral argument from last week. And I'd recommend that anyone who has a chance to just take a listen to that. It was great advocacy, and just really an engaged court where you might have seen a little bit more of the justices' personalities than in some other arguments. I thought it was just a great. If I were teaching a Fed courts class, I want my students to listen to that. But ultimately, I think with that question really is, to what extent does the promise of Rucho hold true that state courts and state constitutions get to provide relief for voters against partisan gerrymandering claims, against partisan gerrymandering maps? And maybe more broadly, to what extent are we going to allow state legislatures who've shown a willingness in some states to really take active steps against voting rights to do so with unchecked authority, do so unchecked, and do so kind of free from the constraints of their own constitutions and the laws that govern their own states and voters. So a lot of really interesting and I think pivotal questions before the Supreme Court. I feel really fortunate to be able to work in this area of the law, and at the end of the day, optimistic that the way that we litigate these things, the way that the court establishes the standards, the tripartite system of government, of checks and balances, these kind of fundamental things that we've come to rely upon, both in the Voting Rights Act context and more broadly in just the kind of rules of the branches of government and how we operate under a system of checks and balances. I'm confident and I'm hopeful that those will hold true so that we can continue to make sure that every American has the right to vote on equal footing with everybody else.
That's great. Thanks, Ava. I echo that. Everyone can listen to Moore v. Harper, can also listen to the Merrill oral arguments as well. It really is a fantastic opportunity to listen to these arguments play out, and the exchanges, I agree, and easy for me to say listening to it as opposed to actually arguing it, but they really are important and fascinating. So thank you for that. Adam, on to additional advocacy work in the states, and I'm sure you'll be able to fill us in on everything that you all have been doing the last cycle and what you have going on right now.
Yeah, thanks a lot, Jason, and obviously to you and Juan and the entire section. Thanks a lot for the invite. So excited to be here with such a really great panel of amazing leaders. I'm with the League of Women Voters of the United States, the national office. For those that don't know, the League has both the national office, the 50 state chapters, and over 700 plus local leagues across the country. And so, when I say that, it makes a difference when you're trying to find out what's happening in elections and voting across the country, because leagues in different areas have different focus. Some places really care about environmental work, some healthcare, some gun issues, but they all share a unifying view and voice around democracy issues and protecting democracy. The fact that there are 50 state chapters and over 700 league chapters also helps when you're trying to find plaintiffs and voters that are facing intimidation, facing the impact of voter suppression laws. And our membership often gets help from partners out in the field like NAACP, as well as great representation like Lawyers Committee and Protect Democracy, and a variety of other amazing groups that work to represent the league in local and federal disputes. So this was an intense year, and in fact, I'll just be frank, it's been an intense couple of years. Since 2020, we have been running around dealing with a variety of things that are relatively new as far as challenges go to the elections front. In addition to some of the longstanding challenges, such as the increase in voter suppression laws, voter intimidation against voters, we've seen the rise in dis, and malinformation using social media to both promote falsehoods around candidates, falsehoods around the way and the process by which people vote, with the intent of changing the elections process. And this is a relatively new phenomenon just in the scope and scale of which it is waged. And it is something that, the league and a lot of other partners out there have been trying to find ways to educate local partners, trusted voices, lift up the voices of local and state election officials to promote accurate and honest election information. We have also seen the growth and the challenges connected to what Professor Rick Hasson refers to as election subversion. And election subversion is where I'd spend a little bit more of our time talking here today, because it is a relatively new framework, and it's framed in three particular ways. And I'll go back and give examples of all three. First, where state legislatures seek to change, alter, or delay the results of an election after it actually has already occurred. And we saw some of the threats connected to this in the aftermath of the 2020 election, where there were efforts by some state legislators to submit alternative, fake, false, wrong, illegal slates of electors for the process. And there have been, since that time, there's been a whole series of framework around whether state legislatures who don't like the results of elections can get involved to change either the submitted certified winner of an election for a federal election, or change the powers of elected or election officials in lame duck sessions or afterwards. We've even seen areas where state legislatures, such as in Arizona, have issued their own sort of audit of the election system. Arizona, for those of you who don't know, went through a huge and incredibly costly audit of their election system because some people claim that the results were improper from 2020. That just finished up this year, finding no significant change, no significant problems connected to the election. And so The first leg of this election subversion framework is on state legislatures that are not happy with the results and attempt to change the results after the fact. And these are things that we should be watching out for, exploring, and pushing back against. Second, the threat and the concern around where election officials, most election officials do a wonderful job in this country. They follow the letter of the law. They're not partisan. There are election officials, and sadly, some increasing number of election officials since the 2020 election who seek to interfere with the conduct, the counting, or to delay the election process or certification of the election. We saw this in a couple of significant examples over the last 2 years, but leading up to the 2022 election. We saw a Mesa County, Colorado clerk who's been accused of tampering with and sharing election information, machine codes, and other types of proprietary election official information with external actors, an attempt to cast doubt on the 2020 election and other practices connected to that there are legal matters proceeding against that clerk, and she did not win her primary election to take the potential spot to be Colorado Secretary of State, but it's a real risk that people feel like they can win power within a party by framing the big lie and election denial materials in this way. Another example of this, of where election officials and people that certify elections have caused problems, is in Otero County, New Mexico, where the commissioners that are responsible for certifying the election, which in every election prior to recent ones have just been a rather rubber stamp. There's no discretion involved in this. It's just these are the numbers reported to us by the local election official. Yes, this is what we're sending on. They refused to certify the election, and a court had to come in, engage, and force the commission to certify that election. And we've seen this in a couple of other jurisdictions, even past the 2022 election cycle, where courts have to come in and actually force and threaten by rule of law and other compliance measures these local election officials that are simply protesting the election or believe that the voting machines are wrong for an improper reasons. And these are things that just had not happened prior to the spread and the growth of the big lie. We've seen, as Kyla mentioned earlier, election officials at the Secretary of State level run on the big lie platform. Luckily, it appears that most of the people that ran on big lie and election denial platforms lost their election, although there were some states that were not contested where we may have secretaries of state that buy into that framework. There are also about 60% of local election officials actually are elected to office. They're not necessarily appointed. And there are at least some indication that people who were election deniers won these races to be local election officials. And that should cause chills down everyone's spine that cares about free and fair elections in this country. We also have to worry about threats towards election officials themselves, because that plays a part in all of this. And this third leg of the election subversion scheme is where individuals, activists, come together to disrupt the practices and process of counting the election, certifying the election, and making sure that certification gets passed on to the appropriate legal body. And we've seen, again, some new and unusual tactics that have emerged in this election cycle. We've seen a variety of self-styled election integrity activists send hundreds of open records requests to local election officials, asking them for all sorts of information and materials under the guise of state open records laws, which, obviously we want to make sure that open records laws are followed. But these are basically copy and paste requests that bog very small counties down in having to require and respond to these requests when they could be doing external voter registration drives, they could be doing voter information efforts and other types of tactics to try to promote the vote and run a free and fair election. So there are also a variety of protests around certification, counting the votes and post-election absentee voting tabulation sessions. We've seen protests in Maricopa. We've seen threats to election officials. Bill Gates, who's one of the Maricopa County election officials, was actually forced into hiding into a recent process because of threats on his life and threats against the election system in Arizona. The other point that I'll raise, and this was a quick moving legal matter, one of the last weeks before the election, there were individuals that were camping out outside of a voting drop box in Maricopa County, Arizona, that were filming and videotaping voters that were coming to cast their ballot. Our League of Women Voters chapter in Arizona, Penny, our league president, reported that she was hearing from members and getting some testimony of how threatened they felt casting their ballot. We're able to get some really good evidence and good testimony from those league members, and working with partners, we're able to get a temporary restraining order issued by a judge that also sent a chilling effect to other actors that were looking to do the same thing in drop boxes around the country. And so it's a real interesting testament to groups with local relationships, local evidence, with national connections and star legal power from a lot of great partners in the voting rights space, of how this was able to be shut down in a meaningful way. And so, going through again, with the election subversion framework, at state legislatures trying to take advantage of the election after the election has been completed, election officials seeking to obstruct, delay, or cause problems with the election counting process, and individuals that are also looking to disrupt the process of vote counting, vote certification. These are all areas that are relatively new that we need to be aware of. Their tactics that are being engaged with in a variety of different ways that I think there's enough examples of threats that lawyers that focus on this, and policy advocates, and just members of the general public that care about free and fair elections need to be focused on. I'll say, the things that I think we should be thinking about as we care about the elections and voting process moving forward is, we still want to see the John Lewis Voting Rights Act and the For the People Act pass. That's something that we cannot give up on, and has had bipartisan support in years past, and it's something that we need to focus on. I'm hopeful, as it was said earlier on in the call, the Electoral Count Act is moving forward, and I know that Caleb's going to give us a rundown of what that means and what it looks like to protect the Electoral College counting process. We need to figure out how to support state and local election officials with funding, with moral support, to stand up with these folks that don't have a political constituency always. Jocelyn Benson as secretary does an amazing job of advocating for this, but we need people across the country that know what secretaries of state do when they do things right, what local election officials do when they do things right, and to really have their back and push back against threats against them, their families, and other types of framework. I think we need to figure out ways to get everyone involved in the elections process. The league has 103 almost year history of working in allyship, in supporting voting, pushing back on voter information, and promoting civil rights and enfranchisement and access. And so I'll leave you all with one anecdote. The league in DC, where you can register and vote when you're in jail in the District of Columbia, the league actually registered voters over the last fall to register to vote, and they actually registered some of the January 6th defendants awaiting trial. And, obviously, what happened on January 6th was the anathema of a free and fair election. But it's something that I think we need to agree that folks that have access to the ballot, no matter who they're going to vote for, we need to find a way to support them and support access to voting. So thank you all for being here. Look forward to the questions.
Great. Thanks, Adam. Appreciate it. Caleb, you were name dropped a couple times there. So last but not least, we'll hand it over to you.
Thank you so much, Jason, and thank you to the section for allowing me to be on this panel. I've learned so much already from all of you. So I think Adam's perfect segue, because I think at least the main win that we hope to see from this Congress when it comes to voting legislation is passage of the Electoral Count Act, which fingers crossed should happen during this lame duck before the end of the term. And so what is the Electoral Count Act, right? You just heard Adam talk about all of these instances where counties, cities, and, in 2020, we even saw some efforts at the state level to not certify the results of a presidential election or a local election. The Electoral Count Act would not solve that issue at the local level or, for state and local elections, but it would go a long way towards solving that issue for presidential elections. And so, speaking of January 6th, this was a lot of the motivation behind January 6th and what led people to believe that if they showed up in DC on the 6th, they would be able to overturn the results of the election, was rooted in this, partial lie, partial truth that the Electoral Count Act was ripe for manipulation. So folks are aware of these things, but one of the lies, for example, is that the vice president could unilaterally, decide to just toss out the election results and say, hey, I'm presiding over the joint session of Congress. I think Donald Trump won, so Donald Trump wins. The Electoral Count Act, the Electoral Count Reform Act, which again, hopefully will pass next week or the week thereafter, makes clear that the vice president, whoever the vice president is, that their role is simply ministerial and that they have no unilateral power to overthrow the results of the election. Another thing that the Electoral Count Reform Act would do is raise the threshold, the objection threshold. So again, going back to January 6th, we saw the members of Congress break out into their respective chambers after one senator was joined by one member of the House of Representatives to object to the results of the presidential election in a particular state, right? And so I believe, for example, like the first objection was raised by Senator Cruz and one member of the House. The threshold would then be raised to 20% of the House of Representatives and 20% of the senators. And now I should flag that it's unfortunately in the House, you're probably going to meet that threshold every time. But in the Senate, you're much more unlikely to meet that threshold. Again, going back to 2020, there were only 7 senators who objected to the results of the presidential election in any given state. So this is another important fix that we hope to see. Another thing, Adam was talking about, states attempting to change the rules or change the laws of how they certify the results of the presidential election after they see the election results. Well, the Electoral Count Reform Act would prevent this by making clear that a state must follow whatever laws or whatever rules they had in place for certifying an election that were in place before election day, right? And there's, a provision in there that allows, leeway for emergencies, specifically force majeure events, if there's an earthquake, if there's a hurricane, something that prevents a state from holding its election. But if it's not something catastrophic or extraordinary like that, the state would have to follow those rules. And also, even if it is something catastrophic and extraordinary like that, an earthquake, a hurricane, those rules, whatever the emergency procedures will be in an instance like that, also have to be in place before election day. So we think it does a really good job at preventing manipulation of the rules after, you look at the scoreboard and see that, you're losing or winning. Another important measure that would happen, which I'm sure Abba may have been paying close attention to, is the judicial review process for when a state fails to properly certify an election. So again, fortunately, in 2020, we saw that, Secretary of States and, the chief elections officials of each state across party lines did the right thing, failed to buckle to the pressure to overthrow the election results. But there's no guarantee that that will happen in 2024 or 2028 or in the future. So under the Electoral Count Reform Act, if there is a situation where a chief elections official refuses to follow the law and certify the results of the presidential election in the state, there's a judicial review process established by this bill. That issue or that matter can be challenged by either a presidential candidate or a vice presidential candidate in federal court under a 3-judge panel. And now I want to highlight a very important development that happened along the way that wasn't in this bill when it was introduced, but fortunately now is in this bill after a lot of negotiation by people in civil rights groups, voting rights groups, all across the spectrum. In order to prevent another 2000, which many people on both sides of the aisle were not happy about. The fact that it seemed like the Supreme Court decided the presidential election. This bill will make sure that the Supreme Court's review of these issues is discretionary. And again, this was not made clear in the original bill, but after a committee hearing this fall, it was made clear that in any instance which a presidential candidate or vice presidential candidate challenges a state certification, the Supreme Court does not have to hear it after the hearing by the 3-judge panel. So this is a very important piece. We think that ECA reform is super important to prevent another January 6th. And we have been working diligently, not just Lawyers Committee, all of the civil rights organizations and democracy organizations like Protect Democracy have been working behind the scenes to try to make sure that this passes. And we do think that it will pass. And I'll just say something quickly here. A lot of us, when we began working on this, were worried that it wouldn't, garner support on both sides of the aisle. But we were, pleasantly surprised to see that members on both sides of the aisle by, a pretty wide margin were in support of this, because despite, no matter what party they were in, most of them were at the Capitol on January 6th, right? So they saw what happened when we allowed those lies to spread, when we allowed people to think that the Electoral Count Act could be manipulated, and they wanted to do something about this, regardless of which party they supported or which presidential candidates they supported. So, that should be a positive voting bill, but as Adam stated, and, I think as all of us know, there is still much work to be done in Congress. I think Abba mentioned, the city of Mobile v. Bolden, right, 1980, when the Supreme Court said, oh, you actually need intentional discrimination. And we saw Congress come back, just 2 years later and say, hey, Supreme Court, you decided this case wrong. This is what we should actually do. Unfortunately, since 2013, when the Supreme Court decided Shelby County v. Holder and, gutted the teeth of the Voting Rights Act, and basically rendered Section 5 meaningless, we have not seen action by Congress to respond with positive voting rights legislation. Another case since Shelby County v. Holder is Brnovich v. DNC, another case where the Supreme Court, really made Section 2 extremely hard to litigate, and Congress has not responded. We have our fingers crossed that Merrill v. Milligan will go well, and that this Congress will not need to respond to whatever the Supreme Court decides in that case. But that may be another instance where Congress needs to respond. So we have been working diligently to try to make sure that Congress passes the John Lewis Voting Rights Advancement Act. And, if I could just be candid, one of the reasons that we got so involved with the Electoral Count Act reform is because originally we wanted to see if we could get some limited voting rights reforms in there, right? Earlier, we were talking about how often the Supreme Court defers to timing in these voting rights cases. One of the fixes we tried to get was a Purcell fix, which is Purcell is the case that the Supreme Court routinely uses to either stay decisions or, toss decisions out, basically saying it's too late to make any voting changes. We thought that that was something, that members across the aisle, both parties, would be, welcome to, because it's something that affects voting rights litigants on both sides of the aisle. We were unfortunately not able to get that across the finish line. So that's one of the things that we hope to see Congress do this term, and that we will be pushing along with the John Lewis Voting Rights Advancement Act. One of the other things that hopefully we can get some bipartisan support for is just making it clear that there's a private right of action under Section 2. Luckily, this wasn't an issue in Merrill v. Milligan, but we are already seeing some judges across the country in federal courts, both at the district level and at the circuit level, entertain this idea that private plaintiffs actually can't even bring a case under Section 2 of the Voting Rights Act, which, if the Supreme Court was to recognize that, would be absolutely devastating for voting rights litigants across the country, and for members of organizations like the League and like the NAACP, who are routinely the plaintiffs in a lot of these cases. So that's, my time is short here. That's the state of voting rights. Some good, a lot of bad, unfortunately, but we are hoping to, reframe. I guess the last thing I'll say is really reframe voting rights as not being about which party wins elections, or being about, whether people are able to actually cast a ballot despite the barriers that they have to face, but more about, what Keila was talking about earlier. How easy is it for you to cast a ballot? Is everyone who wants to cast a ballot and eligible to cast a ballot able to do so easily and able to do so fairly? And that's what we think we have to reframe the voting rights conversation around in order to kind of garner this bipartisan support and ultimately pass voting rights legislation in the 2020s. Because the last time the Voting Rights Act was reauthorized, it received bipartisan support, a 98-0 vote in the Senate, and was signed into law by George W. Bush. So we don't think that this is a partisan issue. We think it's an issue about making sure every single American who wants to is able to cast their ballot fairly.
Caleb, thanks. That's really fantastic, and a good sort of looking forward what we can do. We've been receiving a variety of questions as you all have been presenting, very good questions. I'm going to try to sort of group them and summarize them, and then throw them to you all. There were a couple of questions that talked about state voting restrictions and how do you effectively respond when a new state, and Keila, I know that, Georgia really doesn't have much to do with Michigan. Your voting laws went the other way, but still, how do you respond when states pass these new voting restrictions? And I can imagine that each of you probably have a very different way based on your organization, based on your clients, of how you respond. So just wondering if you could take a couple of minutes to address that question.
Sure. Well, you can use the example of our residents here in Michigan, that they worked together, coalesced, and decided to put a petition before the voters to enshrine some of those rights into our state constitution. That's not the only way. It is a way. Also looking to see, how is your legislature comprised? Is it comprised of people who are forward thinking on voting rights? And if not, then you might need to figure out, do you need to run for office? Is there somebody else that you can propose to get in the race to run for office, so that you have more folks in your state legislature that are proponents of voting rights? That's a couple of ways that, that obviously that you can do, but also just to be really engaged with your elected officials as well. As we all know, the squeaky wheel gets the oil, or however that works. Maybe it's just a door, the squeaky door gets the oil, whichever. But you have got to engage, and we have to remind our fellow citizens that voting is an all year round thing, not just leading up to an election thing. And so you have constantly need to be engaged with your elected officials to let them know that this is of importance to you. And when those pieces of legislation that are forward thinking or are regressive are introduced, that you make your voices heard, that this is either for us, if it is forward thinking, or if it is regressive, then really pounding the pavement to let your voice heard that this is not what is best for our residents.
Adam.
Yeah, I think as lawyers, we sometimes we go to litigation right away. And of course, that always should be a tool that we explore. But I do think trying to figure out how we partner with folks that are in organizing, that are policy, that are in communications in new and different ways. An example, one of our leagues earlier this year, the league in Houston, Texas, had been asking the Secretary of State of Texas to provide some voter registration paper forms because Texas does not have online voter registration, and so you need to have those paper forms to make it happen. And the response they initially got for the League of Houston, one of the largest cities in the country, that they would send them 50 forms. And they were aghast. They contacted the state league, and Grace, the state league president, reached out to us, and we found a way to be able to create a lot of public pressure to show that, for a city the size of Houston, and the fact that there was no electronic way of registering to vote, that the Texas Secretary of State was going to give them 50 forms. It became a big issue. There was a lot of public pressure, and they eventually sent 10,000 paper forms to the state league. And so, there wasn't any litigation filed. There were letters that were very direct and that were timed with smart press and smart communication support. And that public pressure made it clear how ridiculous it was to give 50 forms to a city the size of Houston. And we've had other states such as, Cecile Schoon, who's our Florida League president, has really been pushing back against the DeSantis administration on the aggressive ways that they've gone out after and publicly arrested people that they claim to be voting illegally with their new election police force. And she's been very direct and critiquing how much that sends the wrong message to people about how we should be supporting and encouraging enfranchisement, and trying to find ways, especially with returning citizens, that they can register and cast their vote appropriately. Some of the folks that looks like they arrested in very horrific ways don't appear to have actually been doing anything wrong. And so pushing back against that, showing the human side of how horrible these suppression and intimidation efforts are, have to be other things that we have as lawyers and that we think about and partner with folks that think about work in a slightly different way and pair with our litigation in different ways.
Yeah, I just add to that, find out when your state legislature will be in session. We're coming up. I'm from the state of Texas, so, fortunately or unfortunately, Texas is in session every 2 years instead of every year. And, one thing that people don't know, and is really a testament to the organizing that Adam was talking about, is just how many of these bills that we end up suing over are a lot worse when they're first introduced in this legislature. So I'll just, use Texas and Georgia as an example. Both Texas and Georgia, their original bills that led to legislation, SB1 in Texas, SB202 in Georgia, included either whole or partial bans on Sunday voting, which is when Black voters typically do souls to the polls events. And both of those, either whole or partial bans, were eventually removed from the final bill due to organizers. So if you don't want to run afoul of any lobbying issues, raise public awareness. The moment that your state legislature introduces stuff like this and you see it in the news, wait, our legislature is trying to ban voting on Sunday, souls to the polls, tell everyone, post on social media, get involved any way you can, because a lot of these states, unfortunately, the way their legislatures are made up, they're going to pass a bill that restricts voting every year if they want to. But there is a lot of work that can be done before passage to make those bills a lot less bad than they could potentially be.
So you've talked about state legislatures here a lot, and that's been, as Abba mentioned, sort of the focus of Moore v. Harper, independent state legislature theory. Abba, I'm hoping maybe you can explain a little bit more of the possible ramifications of the adoption of maybe the more extreme views. There's maybe a few different iterations of ISL, but hoping that you can explain a little bit about what might be those particular consequences if the court were to maybe go the other way.
Yeah, I mean, it's kind of, so this case is about partisan gerrymandering under state constitutions. And ultimately, the court has to come up with a ruling that says, did the North Carolina Supreme Court act beyond its Elections Clause authority in finding a violation under state constitutional law? There are any number of ways that the Supreme Court could kind of come at this. And I don't think that I know you've all read the press the same as I have, the kind of parade of horribles that could happen if the court were to adopt the most extreme position, or really honestly any position that on this ISL theory. I don't think that's going to be like the necessary fallout from this case, but it does. The question is, what doors will it open to the next case and the next case and the next case? So, I mean, one thing that we argued is that actually there is over nearly a century of precedent on our side. The Supreme Court has spoken about this before, not precisely in this context, but the Supreme Court had said, for instance, in a case called Smiley versus Holm, that the gubernatorial veto, when part of state constitutions, does apply to legislative enactments regarding federal elections. They have held that in the Arizona redistricting case several years ago, that redistricting commissions are allowed under the Elections Clause and do not necessarily deprive legislatures of their constitutional authority. And that's a pretty extreme thing. Compare those versions to what we have here, which is like, can state courts do what we know courts do, which is look at the law, look at the Constitution, and say, and provide well-reasoned opinions based on facts and law. That is not an extreme, and something that our founding fathers had assumed, and that all states, all federal courts, and I think all elections have kind of worked under this premise for some couple hundred years. So, I mean, in some ways you kind of see in the arguments before the Supreme Court, the North Carolina legislature kind of tries to tap dance around this precedent a little. It says, legislature means legislature, but it kind of means governor sometimes when it's a veto. Legislature means legislature, but, sometimes it means, local election officials. Sometimes it means redistricting commission. Sometimes it means popular referendums. The only thing it doesn't mean is this state court applying this state constitution. And our argument is like, the ways that they kind of tried to dice it up and carve it out and make it seem more appealing and perhaps less drastic only showed how untenable and kind of unsustainable that distinction is. There's no actual rule that you can apply there. But if we were to kind of step back and say, let's pretend that the argument is the legislature only means legislature, and only the legislature gets to regulate federal elections. The logical implication of that, I think, could be grave, right? It could mean that legislatures get to create whole new sets of rules that apply only to federal elections and not state elections, voter ID, absentee voting rules, all the things that we've seen litigated, not in just the last couple of years. All of those state legislatures could basically to provide separate rules for both. And even if the state constitutions prevent certain voter restrictions from state legislative elections, legislatures would have free reign when it comes to federal elections. As a practical matter, that's a problem. As a functional matter, that's a problem. It could certainly, take into its logical implication. What does it mean for the gubernatorial veto when it comes to federal election statutes? What does it mean for redistricting commissions and other attempts by states to cabin partisan gerrymandering? And it's not just about gerrymandering. What does it mean when it comes to empowering state legislatures to, restrict the right to vote in new and creative ways? where really the only check on them is the US Supreme Court. And state voters, state constitutions, state statutes be damned. That is a really, that is a terrifying, I think, thing to allow. And I think we can, I don't know if I've fully imagined all the things that could fall. I don't know if I'm creative enough to think about all the ways that could snowball downhill, but I'm sure many state legislatures are very creative and could think about how to litigate the next case once that door is opened even just a little bit to say, hey, you know, now we get to do this as well. We're so empowered.
Thanks. Yeah, hopefully folks aren't that creative in that sense, right? So every year we do this panel, we always get a variety of questions. Okay, so we sat here, we listened to some horrible things, some optimistic, some examples of voting rights prevailing. The question that keeps coming up is what can I do, right? And you know, the random lawyer, non-lawyer that's tuned in, they always ask, how can I, as just a citizen, get involved with our elections and protect the right to vote, or really try to right some of these wrongs? So I'm going to open it up for all of you. What are just a couple of ways that you've seen in your experiences for folks to really do something and get involved? Whoever wants to jump in first. Caleb.
Well, I wouldn't be a good employee of the Lawyers Committee if I didn't say, of course, volunteer for 866 Our Vote, which is our volunteer election protection hotline. And we specifically have positions available for attorneys to watch, take calls, monitor issues at the state and local level during all elections, not just presidential elections, not just federal elections. So that's one way you can get involved.
Yeah, and echoing, in addition to volunteering for 1866, because it's essential, but it's a time limited service. Folks can sign up to be poll workers in the place where you're at. You can also join a local group, such as your local NAACP, your local League of Women Voters, Common Cause chapter, LULAC. Whatever group that you feel speaks to you in your community that's doing meaningful work, that there's so much work that's happening at the state and local level now. And in fact, that with where things are going at the national level, state and local action, engagement, litigation, and organizing is going to be meaningful. And there are roles for lawyers to play no matter what your specialty is. If you're not a litigator, if you're just someone that does more policy work, or there's a way for you to help out. But I think folks have to stand up in this moment where democracy is being tested in ways that we haven't thought about standing up in a long time. And that means not just doing the thing that we're good at, being a lawyer. You know, it means giving time, treasure, all that other good stuff to really understand the moment that we're in and be able to lend your support.
I just echo all of that. Obviously, I do litigation in courts, and that's not. But to Adam's point, there are so many different ways that people can contribute, and I think one thing that strikes me is just being able not just to pay attention to these things, pay attention to the issues, talk to your lawmakers, show them that you're paying attention, but also to educate others. I was just at Thanksgiving with a bunch of 40 people in my family, none of whom are lawyers. And they all knew something about Alabama and something about North Carolina, enough to be a little frightened. And I think it's helpful to be able to explain to non-lawyers what's really at stake. What kind of anti-majoritarian principles, for instance? What does it mean for the next presidential election? Things like that. I think it's kind of really important to explain to them what the issues are, why they should be engaged, and that they can that participation in the political process is both the thing that we are litigating. We're trying to create avenues for more of it, but also the thing that can make a lot of difference, right? Gerrymandering is a big problem, and sometimes it can be so effective that it really doesn't feel like it matters how people vote and how people try to persuade their elected officials. And that can have a self-perpetuating effect of defeatism and making people feel like, what's the point? And I think if we can do our best in court to undo those structures, but also do our best in the political process, that means not just voting, but also knocking on doors and all the other things, to basically flip that narrative. I think it's a double-pronged attack.
That's great, Ava. Keela, what do you say?
I would echo a couple other things that you can do. For our deep-pocketed lawyer friends, you can donate to many of these organizations. The list that my fellow panelists lifted up, in addition to Southern Coalition for Social Justice, are friends of mine, the NAACP, my former employer, the LDF as well. There's so many organizations that you can donate to. I would get in where you fit in is basically the name of what we're all trying to say. There's so many different ways that you can participate in forwarding our democracy. I would also just say that we have been here before. People utilizing violence and other things to thwart or prevent people from exercising their right to vote is not something new, unfortunately, in our country. It's something that continues to boomerang back. But as our president LBJ said, we shall overcome. I think the issue is that we have to continue to overcome. But with the good people that are on this webinar and those who are watching afterwards, we can overcome if you get in where you fit in. So that might mean for you running for office, because you can use your voice that way. That may be for you to write letters to your state legislature, for you to do it that way. It may just be writing a nice check, and I'm sure many of us will be appreciative of said check at the organizations that are listed here. But also utilizing your voices with the American Bar Association. People listen to the bar when it speaks. And so being a great vocal speaker from the bar was also helpful so that people can see how these different things are impacted and how they are interconnected. That's something that we weren't able to raise here, but how they are interconnected. And lastly, understanding that for many of us on this webinar and that are watching this webinar, our right to vote had to be given to us by someone else. And so we have to understand that it can similarly be taken from us unless we are engaged consistently in this fight for our right to vote. Our democracy can and will be continued if we do the work to continue it. And so I am hopeful that our democracy will be strong in the other 49 states as it is here in the great state of Michigan, but we have to do the work. So I'm excited about the work and to continue doing it with you.
And if I could just add to Keela's wonderfully impressive list of organizations who are actively fighting and have been for so long, I just want to add the National Redistricting Foundation, which has been supporting us through both Milligan and more and a number of other redistricting cases throughout the country in order to fight for fair maps. Like I said, those fights are not over after November 22. They continue on well into the decade and from then on. So I'm so excited to be able to work in this space, to be able to interact with these folks and all of these organizations who are just trying to get it right.
And elected officials, I'm so sorry. Yes, thank you, Ava. And elected officials, I do want to shout out my the elected officials. I'm sorry, elected administrators. That's what I'm trying to say. My state board of Bureau of Elections director, Jonathan Brader, and everyone at the Michigan Bureau of Elections who have been working tirelessly to promote democracy in our state. We see you. I'm grateful for you and all of the election administrators across the country. Thank you for what you do.
Well, you know, as the fight continues, I think we're all fortunate to have you four be right there in the middle, ensuring that right to vote and ensuring fair and free elections. Thank you for taking the time out of your very busy days to share your wisdom and your thoughts with us. On behalf of the section of Civil Rights and Social Justice, we thank everyone for participating in this panel. I will be forever prohibited from doing this again if I don't give a shameless plug as well to this section. The section does wonderful work to advance these issues, to bring voices together. We heard the chair, Juan Thomas, talk about a variety of these options. Get involved, join the section, join our efforts here. So with that, hope everyone has a great holiday season. Thank you again to the panelists, and we will see everyone very soon.